Power Breakfast with TT, 6 to 9 a.m.
So yes, the Deputy National Commissioner for Crime Detection, Lieutenant General Shadrack Sibiya, began his testimony before Parliament's ad hoc committees investigating police corruption and claims of political interference that have been made by Lieutenant General Mkhwanazi. Well, on Monday, the proceedings began with a formal objection by General Sibiya to the participation of two members that he said are criminal complainants in criminal cases against him. General Sibiya argued that the Democratic Alliance's Miss Lisa Marie Schikkeling and Umkhonto weSizwe Party member David Skosana should recuse themselves due to a potential conflict of interest. Well, after consulting his legal team, General Sibiya agreed to proceed with his testimony, but made a point of telling the commission or the committee that he was doing so under protest, because it was his belief that he will be participating in a process that could be, as he put it, a tainted process. By the way, the DA did replace Lisa Marie Schikkeling with an alternative member. Let's hear from the director of Ndou Attorneys and a practicing attorney, Phumudzo Ndou. Good morning to you, and thank you so much for your time.
A very good morning, Thabiso, and also to the viewers of Power FM.
If you can, as briefly as you can, as possible, just define what, when we talk about conflict of interest in a context such as this, what we are referring to, and also when recusal is appropriate.
Yeah, okay. Let me start talking about the issue of recusal first before I speak about the issue of conflict of interest. Now, the principles of recusal are quite straightforward and easy. The issue is whether there is a reasonable apprehension of bias. So there must be an apprehension of bias from the part of the person who's subject of the inquiry, or you could put it an accused in a criminal process. But that apprehension of bias must be based on objective grounds. In other words, it is not supposed to be subjective. Now, in this instance, one can't argue that there is a reasonable apprehension of bias. And the reason why I say so is simply based on the application on the grounds that have been advised by Lieutenant General Sibiya, as well as I think also the minister, if I understood correctly. What they argue is that because there have been criminal complaints that have been lodged against them, the honourable members or the referred honourable members have therefore formed a prima facie view. The rules are quite clear. Holding a prima facie view on an issue does not necessarily mean that you are biased, because a prima facie view will shift when the evidence has been presented. Now, the question then becomes, Thabiso, to say, how do you come to the conclusion that the presiding officer or whoever is going to make a determination of fact it has an apprehension of bias? Such a finding or such a determination or such a conclusion, one can only make it if you believe that no matter what kind of evidence that I advance before the presiding officer or members of the panel, they will not move from their positions. In other words, even if I give them the evidence and even if I try to persuade them as much as I can, they will not move. Now, so it's a very, very, very difficult test to prove. So in this instance, I do not think that either General Sibiya or the minister has been able to advance such grounds. Now, moving on to conflict of interest, I think it becomes exceptionally difficult because this is not...
Before you go on to conflict of interest, let me ask you this now. The fact that here we're not talking about presiding officers. We're talking about people who are sitting in on what also is not even a judicial process here, or even a quasi-judicial process, as we've been told by the terms of reference. Does the issue arise then in this case? Because those members are not going to sit in judgment of the witness.
Yeah, look, it becomes very complex, like I'm saying, because one way or the other, they will have an influence in terms of how the outcome of the proceedings go. There's going to be a voting on the committee will need to make a determination in terms of the report that it will send to the National Assembly.
Correct.
And ultimately, it is the National Assembly that will make a finding. So that is why I'm saying that it's going to be a very difficult hurdle, because ultimately, yes, they are involved in the decision-making process, but they are not the ultimate end in terms of the whole process. They don't have full power. It doesn't end with them. So it becomes very, very, very difficult for General Sibiya to say, well, he doesn't believe that he will not get a fair process, because this process, finally, it's Parliament that has to make the ultimate determination, depending from the report that they will get from the ad hoc committee.
Okay. All right. I want you then to get into the issue of conflict of interest, but we're right up to news. If you don't mind, if I can detain you a little longer, maybe you can just grab a cup of coffee or whatever you need to do right now.
No
and
problem.
then we just conclude that part of this conflict of interest issue. Thank you so much. That is Phumuzo Ndou. He is the director of Ndou Attorneys. We will conclude our chat with him after the latest news at 7 o'clock. 10 after 7 it is on the Power Breakfast. Good morning and thank you so much for staying with us on the Power Breakfast as we into the second hour of the show now. Still have on the line with us the director of Ndou Attorneys, practicing attorney, Phumuzo Ndou. We were just talking about, what happened at the ad hoc committee's hearings yesterday. That's the ad hoc committee that's investigating police corruption and political interference in the criminal justice system. Yesterday, Lieutenant General Shadrack Sibiya began proceedings by objecting to the presence of two members of political parties that are members of the committee, that being Lisa Marie Shekeling and David Skosana of the MK party, Lisa Marie Shekeling of the DA. Well, she was subsequently removed by her party and replaced, but the MK party refused to remove David Skosana, saying that there's no conflict of interest on his party and that he is not a conflicted party because his name had not been mentioned in testimony by any of the witnesses. So, Phumuzo Ndou, thank you so much for staying with us. You were, just as we were going through news, going to explain the concept or the idea behind, conflict of interest, especially, again, in this context of what is not a judicial process or a quasi-judicial process.
Yeah, absolutely. Look, another way in which one could perhaps seek a recusal is if you were to argue that there is a conflict of interest. Of course, the rules or the joint rules of parliament are quite clear, and not just in South Africa but throughout the world, that you as a member of parliament, you should not be involved in any committee that is dealing with an issue in which you've got an interest in. Mm-hmm. So interest could be varied. One, it could be if you are implicated by if it's an inquiry into a misconduct or inquiry into a criminal issue. If you are implicated in the evidence that is there, or if you're implicated by the complaints or the statements, then you've got an interest because you will be subject to the investigation. So you can't participate and be one of the presiding officers or a prosecutor if you've got an interest. Or it could be that maybe some of your family members or your close associates are implicated. That does amount, and that can suffice as a conflict of interest. But another dimension could be, especially in parliaments, which don't only deal with inquiries into misconduct or inquiries into investigations of whatever malfeasance, but they also deal with the promulgation of legislations that can have economic interests or impact in terms of what might happen in the stock exchange or stakes and so forth. Or in those instances where you might stand to benefit. If you might stand to benefit from the outcome of the process, then you do have the conflict, yes.
So then in this case, then we have two members that had actually opened criminal proceedings or criminal cases against the witness here. Could it not be argued that they actually do have a vested interest in perhaps achieving an adverse outcome from this process against the witness, given the fact that they've already opened a criminal charge? And I mean, I saw the MK party sought to say that, he didn't open it in his personal capacity, but a political party cannot open a case. It has to be done by an individual.
So I think that argument is quite relevant that the MK party made, because ultimately every case depends on its own merits. So in this instance, does the opening of a criminal case, would it amount to a personal benefit for the member or for the MK party? Or would they get or obtain an advantage by opening a criminal case? At the end of the day, the question then would relate to, will the MK party or the member himself obtain an advantage by a negative outcome against Mr. Sibiya or the minister in this case? I don't think that they would obtain any personal advantage here. But the issue is that I just don't think that's a good ground, especially in the way in which it has been articulated, in the hearing. Because from what we hear, the argument is that the members have formulated a prima facie view. So because they formulated a prima facie view, the argument is that because they've lodged a criminal case, they've formulated a prima facie view. And therefore, General Sibiya will not be able to obtain a fair hearing. I don't think that is a sound argument because all of us have a prima facie view. And a prima facie view is not a permanent view. It's a view that can change at any given moment in time. So I don't think that's a good ground. So from the evidence that we've been given and from the arguments that have been made at this point, one cannot argue that there's a conflict. And this is why I say so. Remember, Thabiso, in South Africa, for example, you find that prosecutors are involved in the investigation of cases and end up prosecuting those cases. But one cannot argue that because you're involved in the investigation, therefore
that you are biased.
Therefore, because you can always change your view. In other jurisdictions, for example, judges are actually involved in investigations. They're involved in investigations, and also even if you look at a commission of inquiry in its nature, judges are involved in investigations and also involved in the making of the ruling. So one can't argue that because of that, but because of that then becomes a conflict of interest. Yeah.
Fantastic. Yeah. Thank you so much. Phumuzu Ndou, I appreciate your time and your insights this morning. Thank you so much.
You're welcome. Thank you.
Phumuzu Ndou is an attorney and director of Ndou Attorneys. They're helping us with the concept of recusal and conflict of interest. What do you think? What do you make of it? I think that has definitely shed some light, a little bit more light on how these things work. Let me get your thoughts. 0861 987 000. It's 16 after 7.